thank you very much for that introduction, and thank you very much for the advertisement. Now, most of what I've got to say today is drawn from a research project, The Impact of the Criminal Process on Healthcare Ethics and Practice, that we conducted at Manchester a year or so ago. And actually, the question of prosecuting doctors for gross negligence manslaughter was only a fairly small part of the project. Now, the very prospect that a mistake at work, a bad mistake, a bad day at the office, could lead anybody to arrest, trial and jail is scary, to say the least. Even if charges are not pursued and the doctor never enters the dock, the process of criminal investigation and the many years some cases may take only to be dropped take a grave toll on the individuals concerned, the clinicians and their family, and also on the families of the deceased. And the longer proceedings are dragged out, I suspect, the more suspicion is engendered in the family of the person who has died. As Gerard has said, for most of the 19th and 20th century, surgeons and even anaesthetists, and they're the most likely doctors to be prosecuted, I've noticed 2 more have been prosecuted today. Surgeons who achieved some basic level of competence really didn't have to worry, lie awake, thinking about their day in the dock. Judges were very deferential to their medical brethren. So look at this key part of a summing up to the jury on what was actually a trial of attempted murder, the trial of Dr. Leonard Arthur for the attempted murder of a disabled newborn. And the judge says to the jury, "You'll think long and hard before deciding the doctors of the eminence we have heard, representing to you what medical ethics are, have evolved standards that amount to committing crime." It echoes the words of an earlier judge the century before, Chief Baron Pollock, saying, "Well, if the prisoner had been a medical man, I would have recommended you take the most favourable view of his conduct, for it would be most fatal to the efficiency of the medical profession if no one could administer medicine without a halter around his neck," clearly accepting the case for defensive medicine. But delve back a little further into the history in the 16th and the 17th century, and I've actually found quite a number of surgeons in the dock charged with felonious homicide, manslaughter as now, and the charges were usually initiated not by the family of the patient, but by rival healers. Scarier still was the habit of some of the grand physicians seeking to indict the more lowly, in their view, surgeons and apothecaries for witchcraft. At least I don't think any of you have to worry about being burned at the stake. But there are real concerns about your position today. So having heard what Gerard has told us, let's think about when errors become crimes. Now, in England, unlike the civil law tradition of France and much of continental Europe, we haven't traditionally treated negligence as a crime. For an error to become a crime, as is the case in relation to driving a car or running a building site, you usually need legislation. Until about 20 years ago, that was fairly rare. Negligent harm generated a right to compensation, a clinical claim, and in appropriate cases would result in disciplinary proceedings. The one major exception to this principle was to be found in the crime of gross negligence manslaughter, and that fatal errors could and did lead to prosecution, as is still the case. So the outcome of the error, and not the culpability of the error, is what transformed a civil wrong into a crime. In theory, regardless of who the accused is or what she does, gross negligence manslaughter is an offence of general application. Doctors are not singled out for special treatment, and from our research, the evidence suggests that prosecutors are very wary of bringing charges against doctors. A doctor accused of manslaughter is very often pretty unlucky. It's not the degree of her carelessness, but its consequences that dictates vulnerability to criminal charges. Dr. Prentice was a young house officer, one of the many charged with administering vincristine intrathecally. His counsel said, "Since doctors are fallible, they will make mistakes. Whether they cause death may be fortuitous, in the sense that the mistake may have been corrected by someone else supervising the procedure." Now, Dr. Salmon and Dr. Prentice were the kind of Dr. Sellu case of 20 years ago. They were looking after a 16-year-old boy with leukemia. His chemo regime required him to receive vincristine intravenously and methotrexate intrathecally. Dr. Prentice was a pre-registration house officer, just out of med school. Dr. Salmon was a house officer. Prentice had never administered either drug before or had any relevant training. The latter had very limited experience, and he thought he was just supervising the administration of the lumbar puncture. Didn't know that he should have been checking what Dr. Prentice was doing in terms of the drug. Prentice made this terrible, terrible mistake, and the boy died. Very careful reading of the vials of both drugs, and I've actually seen the vials and how tiny they are, would have indicated the right mode of administration, though not at that time the disastrous effects of getting it wrong. And they were both convicted of manslaughter. But the judge said, you could have been helped more than you were helped. You're far from being bad men. Now compare Dr. Prentice with another case, Kay against Ayrshire and Arran Health Board. Their doctors negligently administered an overdose of 30 times the proper dose of penicillin to a little boy. The skill of the intensive care team saved that child. Had he died, I think it's highly likely that the Procurator Fiscal would have introduced a criminal investigation into culpable homicide, the Scottish equivalent of manslaughter. And does a tragic death alter the culpability? Does it alter the question of whether a mistake should lead to prosecution? The late Professor John Smith was one of the most eminent lawyers ever writing about criminal law. He didn't like the law on gross negligence manslaughter generally. He thought a law that only punished fatal errors didn't make sense, and he gave the example of the careless father who keeps colourless weed killer in a lemonade bottle within his child's reach, and the child drinks the poison in mistake for lemonade. Smith says, my moral culpability and my dangerousness as a father and a member of society is no less the case when no harm is done than in the case where death occurred. So why does death make negligence criminal? Is it sheer practicality? That in the Smith example, if the child didn't drink the weed killer, who'd ever know about his dad's carelessness? But what if the child's mother, thirsty and exhausted from gardening, drank the poison but survived with multiple disabilities? No offence would be committed in England. A Victorian judge, the amazing Mr. Justice Stephen, would justify the anomaly that the chance, the bad luck of a fatal outcome makes one man a criminal while the other goes free, thus, by saying, well, in one sense, they've each committed an offence, but one's had bad luck to cause a horrible misfortune and to attract public attention to it, and the other the good fortune to do no harm. Both deserve punishment, but it gratifies a natural public feeling to choose out for punishment the one who has actually caused great harm, and the effect in the way of preventing a repetition of the offence is much the same as if both were punished. Pour encourager les autres. Stephen sums up one of the issues we must address. Why would we wish to make certain sorts of errors criminal offences rather than simply allow anyone injured to get compensation and professional disciplinary bodies to investigate and ensure that doctors, surgeons are competent at their jobs? The chance of a fatal outcome seems illogical, and as Smith said, the criminal law should either not punish negligence at all or allow for offences of gross negligence causing injury. Smith, who believed that we should have as little criminal law as possible, favoured the former. So are we talking about deterrence? Well, if so, prosecution for medical manslaughter doesn't seem to have much deterrent effect. The dreadful error made by Dr. Prentice, injecting vincristine in the wrong way, has, as Gerard said, been repeated on numerous occasions. And if deterrence is our main aim, then it makes no sense to criminalise only fatal errors rather than gross negligence causing bodily harm as well. And I'll come back to the question of whether criminalising errors makes sense a little later. Are we really engaged in retribution? So some quotes from families of victims of what's often called medical manslaughter. The midwife's failure to accept any responsibility or show remorse has made me bitter and angry. A husband whose wife died after an epidural drug was injected in her arm. 8 months for killing my son, it's ridiculous. It leaves a sour taste in my mouth. The father of the boy who sadly died at the hands of Dr. Mulham. Or are we simply giving some kind of symbolic value to life itself by punishing fatal errors only? Then there's a practical issue. Many patients who die, even after appalling error or recklessness, are terribly ill, and so the CPS can't prosecute because they won't be able to prove a significant contribution to the death. Another factor seems to be the attitude of the deceased's family. If you're a surgeon who sadly makes a fatal error, the nature of the family may be as crucial to your fate as the nature of your error. While the media always tend to focus on families seeking retribution, our research showed initially that many families wanted explanations, apologies, reassurances. They weren't keen on prosecution until there was delay, obfuscation, and the very complex process of all the different agencies who become involved in investigating the death. I would simply note here that the lengthy, cumbersome, and sometimes conflicting processes that kick in a medical death pose the possibility that it is the process as much as the substance that is damaging to all the parties. We can debate these questions in a little while. Putting my cards on the table, I agree with Smith. The outcome of negligence should not determine criminality. If we want to punish gross errors resulting in death, then logically we should also punish gross errors resulting in serious injury. So what makes negligence gross? Well, Gerard has started to touch on that, and there's no satisfactory answer, but please don't blame us, blame the courts. So he's already led you to this quote. The negligence went beyond a mere matter of compensation, showed disregard for the life and safety of others, as to amount to a crime against the state and conduct deserving of punishment. Now, if you look at that statement, you might think, well, what it really means is there must be evidence over and above a really bad mistake. There must be something that suggests that the doctor just didn't care about the welfare of the patient. There must be recklessness. And in the 1970s, when I was growing up in the law on gross negligence manslaughter seemed to have evolved to require proof of subjective recklessness, proof of some kind of real badness on the part of the accused. A mistake, even a dreadful mistake, wasn't enough. Andrew Ashworth has said it came to be assumed that gross negligence manslaughter had been absorbed into and replaced by reckless manslaughter. Now, if that was true, that it was only cases where the person really didn't give a damn, it's not surprising there were very few prosecutions of doctors, and thank God that was the case. And then we get to the case that Gerard has mentioned of A DiMarco. Actually, the case of Dr. Prentice, the unfortunate young doctor, on the appeal was consolidated with that of Dr. A DiMarco and an electrician called Mr. Holloway. And then the Court of Appeal first, and then the House of Lords, said, no, it doesn't require subjective recklessness. There's no need to show disregard for the patient's welfare. There's no need to show unjustifiable risk-taking. You just have to prove gross negligence. And Dr. A DiMarco, Dr. Prentice's appeal succeeded before the Court of Appeal. Dr. A DiMarco went to the House of Lords. The Court of Appeal did do a slightly better job than the House of Lords in providing us with a test. We might want to come back and discuss that later. They at least set out a number of questions that the jury could consider, but we get back to this circular thing, is it conduct deserving of punishment? So Dr. A DiMarco's appeal failed. You've seen the quote that Gerard gave you from Lord Mackay. The jury must consider whether it was such as should be judged criminal. And I still struggle to find any clear guidance of what that means. And in relation to Dr. A DiMarco, he was a pretty dreadful doctor, but there's no evidence that he failed to do his incompetent best. He'd never assisted at such surgery before. He took over part way through the operation, and the evidence was he'd moved about 12 or 13 times from locum position to locum position, always accompanied by the best of references. So you actually start to wonder who should be in the dock. The test set out by the Court of Appeal lacks precision. The central message is that you don't need recklessness, and that, of course, creates greater scope for prosecuting surgeons whose negligence results in death. And Ferner and McDowell argued in a paper in 2006 that the CPS had an appetite for prosecuting doctors, that they saw it as an emotionally satisfying way of exacting retribution. Now, our research into CPS files in the paper from Griffiths and Sanders, they've looked at CPS files from 2004 to 2009, suggests that actually the contrary is true. The CPS is much more reluctant to prosecute doctors than anybody else and looks for some evidence of badness, effectively is applying a recklessness test. Gerard has related a number of cases, and the factor that I again would note and emphasise that a sure way of increasing the likelihood of criminal charges and the likelihood of jail is to try and cover up afterwards. But that still doesn't take us away from the basic question of do we need more than even a very bad error to make conduct criminal? Should we restrict individual criminal responsibility to death or injury for reckless conduct? In their wonderful book, Alan Merry, a very distinguished New Zealand doctor, and the Edinburgh lawyer, Alexander McCall Smith, turned millionaire novelist, argue that only violations, effectively recklessness, and not error, should normally be the business of the criminal law. Andrew Ashworth, who's today's doyen of criminal law, disagrees. Negligence, Ashworth says, should engage the criminal law as long as the defendant had the capacity to avoid causing harm. So experience, conditions of work, demands of the job, adequacy of systems might all be taken into account. Negligence should be a crime not simply as a deterrent, Ashworth says, or to allow retribution, but because failing to protect others from harm when it's your duty to do so is culpable. But note his caveat about capacity. In fact, although Ashworth seems to be leaning much on the side of prosecution, his test is such that prosecutions might be rarer. I would side with Mary McCall-Smith and argue that only where there is disregard of patient welfare, where there is a violation, conduct that is a betrayal of trust, should the criminal law be rightly involved. It's long been an offence for any health worker willfully to neglect or ill-treat a patient who's mentally ill or incapacitated. The threshold for such a test is high. You may be aware that the Criminal Courts and Justice Act 2015 now extends the offence of willful neglect to protect all patients and all paid care workers, including doctors. Some doctors see the addition of a new crime as further evidence of the law being out to get medics. But again, I disagree. Punishment and deterrence of people who are in a position of trust and act without regard for the welfare of others is properly the business of the criminal law. Badness should be the business of the criminal law, not mistakes or even incompetence where the accused lacks insight into his adequacy. Of course, again, as Gerard has said, the badness may rest elsewhere. And Quick backs up what's been said before. Virtually all medical manslaughter convictions, while concentrating on the acts or omissions of an individual, reveal problems of organisation, planning, design and communication. If badness is at the heart of crime, then outcomes should matter less. But of course you can't dismiss outcomes, for human nature will always find the driver who kills the cyclist she knocks off her bike as more culpable than the driver who merely causes bruising and concussion. So where does this leave the doctors? My preference would be to see gross negligence manslaughter replaced by reckless manslaughter. But I doubt this will happen. Should there be a special doctor's defence, some kind of immunity threshold for doctors and surgeons in particular? I think not. A cautious prosecution policy, better integration of all the bodies investigating the death, and reviews of sentencing are called for. The CPS seeks to ensure that all gross negligence manslaughter charges against doctors are dealt with by a specialist unit from the start. The police are supposed to involve the CPS from the start. That doesn't always happen. And I think there are genuine problems on sentencing, illustrated by the case of Dr. Garg and later cases. It's very difficult to disentangle how much he's being punished for what he got wrong over that weekend and how much he's being punished for trying to cover up. My colleague Hannah Quirk has recently examined sentencing policy in this lovely named paper, White Coat Crime, and she is concerned about the outcome that the judges now place on harm rather than culpability, and the emphasis very much on punishment, when some of the other traditional tests for a custodial sentence, like incapacitation, simply don't apply to doctors in these sorts of cases at all. Alas, I suspect that in seeking to narrow the role of criminal law generally, I'm on the wrong side of history. The trend in legislation is to invoke the criminal law to address any form of undesirable or suboptimal conduct and to regard outcome as integral to crime. In the context of medicine, I regret to say a further factor may increase resort to the criminal law. As many of you know, and perhaps be relieved to know, the abolition of legal aid for most clinical negligence claims has come about, and that, I suspect, may well drive more and more patients and families to demand their version of justice from the criminal courts. Please don't shoot the messenger, that would be murder. Thank you very much.